Hey everybody, welcome back to Comic Crow, and we have an update from the Twitter, I guess, X account, at the Manson Cases. Guys, give this person a follow, here, I'm doing it right now. Give this person a follow if you want to get more updates directly on the Marilyn Manson situation, because they seem to be doing an incredible job at sourcing through what's going on with this lawsuit, but I want to talk about it as well, which is why I'm doing the video. So check it out if you just want the direct news. I don't shame you for that, but if you can, do me a favor, subscribe to the channel if you like the content, give us a like, and please share the videos that we are putting out, get the story out, and share these tweets as well, okay? Like I am doing, see, I'm doing it right now. Okay, so we have a new filing in Jane Doe versus Marilyn Manson responds to request to prevent Marilyn Manson from testifying in his own defense at civil trial, which is kind of nuts to me, right? Like, this is a civil trial. Jane Doe Accuser, who we now know is Chloe Black, somewhat of a musical person, doesn't seem to be very famous. Just saying that, not a dig or anything. I'm certainly not famous either. But they're suing him in a civil trial. They're not going to the police. They're not pressing criminal charges against him. They're taking him to a civil trial, trying to shake him down for money, right? Because the money is going to make all the bad touches go away or something. What's frustrating about it is they also do not want him to testify in his own defense. And also, while they were giving deposition without notifying the judge, they suddenly remembered memories, these forbidden, forgotten memories from 10 years ago, repressed trauma. And they, on their deposition, started hurling out new allegations, new stories against Marilyn Manson, almost like they were just pulling it out of their ass. Actually, it's pretty funny. One of the claims is a claim originally made by Ashley Morgan Smithline. And for those of you who remember from our previous video, Ashley Morgan Smithline is the woman who came out with accusations against Marilyn Manson, then later recanted and said Evan Rachel Wood had pressured her into making those statements. So now, during her deposition, Jane Doe, aka Chloe Black, suddenly has this repressed trauma memory dump and hurls out the same claim that was previously recanted from another accuser. Can't make this shit up, guys. It's actually nuts. Okay, so let's start digging into some of this stuff. So to start, Marilyn Manson attorney Howard King addresses improper attempts to smear him across her motions. Yeah, it is a smear job. It is. And I think here's the problem. And this is where Marilyn Manson I don't want to say he fucked up, but I think he made a big mistake. Previously, he had an accusation with an accuser named Esme Bianco. Now, he made a settlement with that woman. I don't know the full details behind the settlement. Either, you know, he was clearly guilty and he was terrified and he settled, or he thought, hey, if I settle this, it will go away and I can go back to doing music. Well, about a week after he had made that settlement agreement and it was announced, then Jane Doe Accuser popped up out of fucking nowhere and dropped all of this stuff on him. So yeah, it's more and more seeming like Jane Doe, aka Chloe Black, is just trying to smear him as relentlessly as possible, get more headlines to write bad things about Marilyn Manson so that he gets pressured into making a settlement. Now, here's where she might be, like, completely stupid. You've already dragged his name through the mud. You've already had a documentary made about this guy. You've already told everybody what an evil, awful person he is. Settling with her now does absolutely nothing for Marilyn Manson. In these situations, as much as we want to deny it, you are guilty until you are proven innocent. You can't go lower than rock bottom on these ones. You really can't. So trying to pressure him, from what I can see, into making a settlement agreement so that she stops does not benefit him in any way, shape, or form. His reputation is already garbage for most people. Let's keep reading into it. I had to put that out there. I don't know what the legal strategy here is, but it seems like it doesn't exist. Defendant Brian Warner, who is Marilyn Manson, that's his legal name, submits this combined opposition to plaintiff Jane Doe's motion in limon, 1-7. I'm not a lawyer. Don't blame me, guys. Warner addresses each of plaintiff's motions below, but first he asks the court to not put any weight on plaintiff's improper attempt to smear him across her motions under the guise of the litigation privilege, with repeated defamatory and unsupported references to him being a serial sex offender. Plaintiff offers no evidence to support that false claim, and Warner has not once been adjudicated in any court, civil or criminal, to have committed any such offense. Also, as plaintiff knows, one of Warner's accusers publicly recanted her allegations against him, stating that she had been manipulated by others into making the false claims. In any event, the scandalous claims have no relevance to the legal or evidentiary questions at issue, nor plaintiff's claims they should be disregarded. Yeah, look, you're in a legal court. You're not on social media. On social media, you can call this guy whatever the hell you want to call him, unfortunately. But when you take it to court, you can't sit there and say, well, this person made that claim. This person hasn't actually pressed charges, hasn't taken him to court, is just making that claim, and you're trying to use it as proof to bolster what you are saying. Now, that plays well on social media, right? It plays well on social media. In a court of law, it's typically not going to get you very far. It really isn't. According to Howard King, Manson gave attorneys 1 month more notice than courts have said is sufficient. Manson gave 13 days before fact discovery closed, 41 days before trial. According to King, Manson waiving his Fifth Amendment right is proper based on previous rulings. He has the right not to self-incriminate. Manson has waived that right because he wants to testify in this civil proceeding, and that seems to be what this Jane Doe accuser is trying to stop from happening. She'd much rather be able to put it out there, put her statements out there, and then go to everybody and say, hey, look, he's hiding behind the Fifth Amendment. That's because he knows he's guilty. Unfortunately, even though we're told that you should not take somebody using their right to the Fifth Amendment, you shouldn't take that as a sign of guilt. Most people do. Most people do. In fact, we've even seen times where lawyers have tried to imply that because somebody acted, took their Fifth Amendment privilege, that it was proof of their guilt because they weren't willing to speak. Yeah, that doesn't, again, I don't think it's going to work here. But I'm going to jump into the next topic because I don't want to read through a bunch of legal language. That's essentially what this states, though. Howard King states Jane Doe admitted in her sanctions request, making new allegation at her deposition. The claim is that Marilyn Manson locked her in a soundproof room in his apartment, something one previous accuser stated and later recanted earlier this year. Again, that would be Ashley Morgan Smith line. So this wasn't, the judge didn't know this was going to happen. Nobody was notified this was going to happen. During her deposition, Chloe Black, your Jane Doe accuser, decided to tell everybody, oh, repressed trauma memories from 10 years ago have suddenly flooded back into my skull. And I remember now I was locked in a soundproof room. Oh man, it sounds like a bad CW show. Plaintiff also admits that she surprised Warner with a new undisclosed claim at her September 7, 2023 deposition when she testified that she is continuing to recover new memories from more than 10 years ago. One of which includes Warner allegedly locking her in a soundproof room in his apartment, which did not have such a room. Given plaintiff is making up new 11th hour claims weeks before trial, it would be even more improper to keep Warner from introducing the evidence and information that he disclosed more than a month before trial, or to keep him from introducing evidence to rebut the brand new claims. What's more, Warner did not invoke the privilege in response to all discovery in November 2021, and plaintiff offers no reason he should be precluded from testifying about topics to which he never invoked the privilege. Finally, in relation to Jane Doe trying to exclude Marilyn Manson from testifying in his defense, Howard King states that Jane Doe has not shown that Manson misused the discovery process, but even if she had, it's not justified. Well, I don't think it would ever be justified. I don't think you could ever justify it. I don't think there's ever a way to justify saying that somebody doesn't have a right to testify in their own defense. He's being accused. He has a right to make a statement about it. That is insane. That is absolutely insane to me. But again, if it's true that Jane Doe, Chloe Black here, is using the legal process to push out claims knowing that she cannot be taken to court for defamation over it, well, at that point, it seems like she's the one who's abusing the legal system. I mean, that would be my layman interpretation of what's going on here. But I don't know if we necessarily need to read through this. I'll put it up on the screen if you guys want to pause and go through it line by line. It's just, I don't think you could ever justify taking somebody to court, suing them, and then saying they don't have a right to defend themselves. In reference to Jane Doe trying to exclude Chris Brenna from testifying because of her new claim of being locked in a soundproof room, he is a witness. As Howard King claims, this apartment did not have such a room, meaning Chris Brenna and others will testify to this. Yeah, so how could you introduced a brand new claim out of nowhere during your deposition. So this was the 7th, okay? This is on the 7th. That means what? 15 days later, okay? 15 days later is where we are at right now. 15 days ago, this quote-unquote anonymous accuser, aka Chloe Black, put out a new story and now wants to prevent Marilyn Manson from calling a witness to refute her brand new story that she just put forward 15 days ago. This is, I mean, look, let's say it all got denied. I don't think I would ever trust any type of decision to come out of a trial like this. These are insane claims. And I don't know if this is normal because, you know, we've gone through at least a few lawsuits on the channel before, right? And I've looked into other lawsuits, and I've watched things from like Ricada Law, Legal Mindset, even Nate the Lawyer. I've never seen anything like this that I can remember that's so brazen an attempt to shut up the person you are accusing as you're accusing them, as you're taking them to court. You're also trying to shut them up. You're also trying to prevent them from calling witnesses to refute your claims. Oh, man. So, on top of those arguments, the witnesses targeted by this motion have information to rebut plaintiff's new claim about him being locked in a soundproof room in Warner's apartment, which did not have such a room. Plaintiff asserted this new claim for the first time on September 7, 2023, weeks after Warner identified these witnesses in amended discovery responses. Plaintiff offers no reason Warner should be precluded from calling witnesses to testify about the new claim. Yeah, I mean, yeah, exactly, right? That seems like a no-brainer. Moreover, these witnesses were known to plaintiff before Warner identified them in discovery. So, again, she's known these people were going to be called. She's now trying to get them basically like voided out, get them rejected from testifying in the trial as she introduced a brand new claim out of the blue, out of nowhere. In reference to Jane Doe trying to exclude Groupie actress Paula Weiss from testifying, Howard King states that they only plan to call her as a witness if Jane Doe has Groupie played at trial. Doe claims this unreleased horror film traumatized her and believed it was murder. This doesn't seem like it would have much to do with her claims of being sexually abused or whatever. But again, it's an attempt to make Marilyn Manson appear to be a horrific monster. Because when most people think of Marilyn Manson or see him, you know, and we'll even use it in the thumbnail, when most people see Marilyn Manson, he doesn't appear to be like a normal human being, okay? Like, and as normal can be, right? He looks a little off. He's got a very particular style that is off-putting to people. So it seems like one of the goals here is to play this this unreleased film, right? And try to imply that this is who he is. This traumatized, this poor, somewhat maybe failed song person, Chloe Black or whatever. And if they do that, they're going to call one of the actresses for the film to to refute what she is claiming, that this was in any way seen as like actual murder. Like, a plaintiff is allowed to introduce the 44-minute horror film together with her false claim that she suspects Warner murdered the woman in it. Warner will need to call Paula Weiss, the paid professional actress, to do what he can to minimize the prejudice caused, which could never be fully cured. Dude, she's going to try to claim that in this horror film, Marilyn Manson literally murdered somebody. And so, if she does that, they want the right to call a witness to say, hey, I was there. This woman is like high as fuck. This is bullshit. Oh man. There's more. That's the crazy thing. This trial, it probably won't be televised. I wish it was televised, because this is insane. In reference to Jane Doe trying to exclude Tony Chula, I hope I said that right, Manson's former manager, he can testify against Doe's new claim of there being a soundproof room in his apartment, and against claims she moved in with Manson, an apartment that was his home, office, and studio. Well, that would seem important. If your claim is that, hey, I lived with him, I moved in with him, and he locked me in a soundproof room, having his former manager who did business with him because he did business out of that apartment come in and say, hey, nobody else is living with him, and there was no soundproof room. This woman is on crack or something. It seems important. It seems important. What is the actual justification for getting these people recused? I want to know. I want to know what they were thinking. In reference to Jane Doe trying to exclude Jordy White, Manson's former band member, he can testify against Doe's new claim of there being a soundproof room in his apartment and refute she moved in with Manson, and that he gave a key to her apartment to her. Yeah, right? Similar to Tony Chula and Jordy White, Chris Frenna can also testify that Jane Doe did not have no, it's probably just the way he wrote it, that there was no soundproof room. She did not live with Manson, nor have keys to his apartment. I don't know if they could really say anything about the keys to the apartment, because that'd be a little bit harder to prove. But at least on the first two, that would be easy to refute. Last, Howard King details why Manson's wife, Lindsay Usage, I don't know how to say any of these people's names, should be able to testify at trial in similar fashion to Tony, Chris Frenna, and Jordy White. She was present in his apartment regularly, and that Jane Doe did not live there. Look, I mean, maybe the wife's willing to lie for him, but like, come on. His wife is like, oh, I was living in his apartment and he was married with the wife. Yeah, I don't know, man. I don't know. It seems like the wife would have immediately divorced and taken him for every little penny that he had if that was the case, right? Howard King also states Jane Doe should not be able to introduce evidence of Manson's alleged bad behavior, and that Jane Doe might try to sneak in new evidence just like this new allegation, by her repeated references to unproven public allegations. Note that plaintiff wrongly states Chris Frenna was in Groupie. So, yeah, I would say that's probably true. I think it's very true, because here's the thing. If it's a jury trial, okay, you would want to poison the jury as much as humanly possible by telling them this is the way it works on social media, right? It's not supposed to work in a courtroom this way, though. But this is how it is on social media. So, of course, that's how she wants it to be. Of course, that's how she wants it to be. She definitely wants the ability to introduce any type of claim. Unproven, doesn't matter. If you actually have a named accuser, doesn't matter. She absolutely wants that, because she can poison the well so bad that they would just think, oh, look at all these women are making these claims. That must mean he's guilty, right? The way the human brain works is actually pretty simple. Anyways, guys, that's it for the update here. You need to give At the Manson Cases a follow. Okay, you absolutely do. Because this trial is going to be insane. This trial is going to be nuts. Marilyn Manson versus Jane Doe accuser Chloe Black. Let's see how it goes.